Hello and welcome to the program. I am DEJI360. Almost 3 years into his second term as Ebonyi State governor and currently nursing a presidential ambition, the tide now seems to be turning against Governor David Umahi as he is currently locked in a legal battle to retain his governorship seat. Earlier in the week, a federal high court judge in Abuja sacked Umahi, his deputy Igwe, and 16 other lawmakers for defecting from the People's Democratic Party, under which they contested and won election to the All Progressives Congress APC. Now, Justice Iyang Ekwo rules that the votes they all got during the election belong to the party and not the candidates. And so what that literally means is that because they have left the PDP can then take back the votes and pass them on now to other persons, well, the party deems fit. That's quite strange if you ask me, but that's simply what the judge said. He also dismissed the argument that the governor and deputy governor enjoy immunity, adding that the provision of the Constitution does not apply in the current situation. Now, he therefore ordered INEC to receive from the PDP names of persons to replace Umahi and his deputy, or in the alternative, conduct fresh gubernatorial election in Ebonyi State. Now, that's a bit confusing because it simply means INEC will have to decide whether it simply wants to receive names forwarded to it by the PDP or go ahead now to issue them with certificates of return or conduct another gubernatorial election. Now, which one INEC will pick is difficult to tell, and that's where this is all strange. Well, Governor Umahi and his lawyers have faulted the verdict and they have filed an appeal against it. Nonetheless, the verdict has been a big talking point in the country, and one fundamental question arising from it is who exactly owns the votes scored in any election? Do the votes exclusively belong to the political parties so that they can do as they please with the votes? They can transfer the votes actually to another person in the event a governor, for instance, defects to another political party? Well, everything is a bit confusing. Joining me now to discuss all of this is GT Igwe, who is a legal practitioner. Mr. Igwe, thank you very much for joining us on the program. Let me start by asking you to help us make sense of this judgment, because even to me, it's actually confusing.
Now, thanks you, Deji, for inviting me to your program. This judgment has again brought to the fore the crisis in our judicial system, in particular regarding conflicts of judgments and pronouncements of our courts and multiplicity of actions on the same subject matter. Now, you can recall that before the PDP was able to, come out with its convention, there were a number of cases in court regarding the status of the erstwhile chairman of the PDP, Uche Secondus. And there are a number of cases that were instituted by the same parties on the same subject matters in different courts. And indeed, the National Judicial Council, Nigeria can recall, intervened on that occasion. And following that intervention, some of the judges recently had been sanctioned. So when this case came up again, the latest one in Abuja regarding the status of Governor Umahi, whether his defection from the People's Democratic Party to the All Progressive Congress, APC, was a ground for his removal from office, and I'm using my words advisedly, or for declaring his gubernatorial seat vacant or not. And Nigerians were wondering what's the latest from the judiciary again, particularly because a court in Ebonyi State had ruled on the same subject in his favor, stating that regardless of his defection, his office was not vacant, his office was not up for grabs, and that it could not be replaced. So when this court in Abuja ruled on the same subject matter, Nigerians, were just wondering, not only lawyers, what was going on. Now, what the latter judgment, not the latest now, latter judgment, is saying is that Well, by the provision of Section 221 of the Constitution, which, if you ask me, is totally irrelevant to the subject that was placed before the court, this governor haven't defected, and courts haven't ruled in some cases, particularly in the case of Amechi and INEC, 2007 Nigerian Weekly Law Report, Part 1080, to the effect that the votes cast for a candidate in an election, governorship election, were indeed the votes cast for the party of that candidate, and that those votes were transferable. Following that decision and then making allusion to other decisions, the one on the Sanfaras case and all that, which I will explain in a moment, Governor Umahi haven't defected, couldn't have defected to the APC with his votes, and that therefore he had abandoned those votes and he had ceased to be in office by virtue of that defection. Now, the problem with that judgment is that that judgment has no constitutional backing. There is no general specific provisions of the Constitution that provides that once a governor defects from the political party that brought him to power to another political party, then he should lose his gubernatorial seat. There are provisions in the Constitution regarding legislative seats, and we saw that play out, in a way in Kogi State when Governor Senator Dino Melaye was being recalled. A legislator can be recalled. The seat of a legislator can be declared vacant on the ground of defection. There are constitutional provisions to that effect. But regarding the defection of a governor, there is no constitutional provision to the effect that once a governor defects, then his seat will become vacant. And indeed, that was the question that was determined by the Supreme Court in the case of AGF, Attorney General of the Federation, and Atiku Abubakar. When the former vice president, Atiku Abubakar, owing to the nursing of his presidential ambition, which he thought was not going to materialize in the PDP, defected to the then AC. And on the ground of that defection, there were moves to declare his seat vacant and all that. And he went to court. And the matter went to the Supreme Court ultimately, and the Supreme Court held in that case, which is reported in 2007, Part 1041, that the seat of a vice president, a president, governor, deputy governor, can be declared vacant. The office cannot be declared vacant on the ground of defection. In other words, the Supreme Court settled the point that defection is not a ground for declaring the office of any of these executive officers vacant and all that. So that issue has been settled. It may well be that many people, particularly the party producing that governor or vice president or the president, may be angry. They may say that it is immoral for that person to have wine and dine with them, to have used their platform to get to a political office and then abandon that platform, They may raise hell on the ground of principle. They may say that it's unconscionable on the part of that governor to do that. But the law is about what the law is as of today, not about what the law may be tomorrow. That's why we talk about lex lata, what the law is as of today. And what the law is as of today is that defection is not a ground for declaring the office of a governor vacant. The other problem with the judgment is that the court in the latter case in Abuja couldn't have pretended to be unaware of the earlier decision of the High Court of Ebonyi State on that same subject, which raises the issue of multiplicity of actions that I talked about earlier, of conflict, of judgments of court, and ultimately of abuse of court process.
The question is this. It's good you've brought this up, because that's
Yes,
exactly what I wanted to ask you. So in this case now, which court will the governor obey? Which court's decision now would, if you like, supersede? Should it be that of the Ebonyi State High Court,
well,
or
it
the
is
Federal High
convenient
Court?
it is convenient for the court to obey the earlier judgment. It is convenient for him to obey the earlier judgment. If I am a lawyer, I will tell you that the governor has no business obeying the latter because you see, there's a proverb in these parts that says that an old man that ties the cob of the corn to his waistcoat makes himself the playmate of chickens. So a court that, gives a judgment like that is inviting disobedience. That's the point. There's a judgment already given by a high court of coordinate jurisdiction, and another court then gave a judgment, and that court then expects the beneficiary of the earlier judgment to then abandon the benefits and then succumb or surrender to the dictates of the latter judgment. It won't happen. People won't do it that way. More so when the latter court is not an appellate court. It's not a court that is
another question
in the hierarchy of courts.
You're quite right. Another question is, I'm just surprised. Why didn't the people who felt aggrieved with the judgment of the Ebonyi court, those who went to the Abuja court, Federal High Court Abuja, why didn't they go on appeal against the decision of the Ebonyi court?
Exactly. Exactly, DEJI. If the feeling was that, it was a state high court that decided that case in favor of the governor, if you elevate it to the Court of Appeal, it becomes a federal high court, a federal court of appeal. It's a federal court. Supreme Court is a federal court. So if their thought was that there was manipulation at the level of the state high court, and that was why that judgment was delivered in the favor of the governor, which is not what I'm insinuating, because I have no facts to so insinuate or no reason to so insinuate. When they get to the court where 3 heads or 5 heads are better than 1 head of a judex that is sitting alone in the high court, they have brighter chances, I suppose, to have their case determined very well, possibly in their favor. Why they didn't have that patience, is what I don't understand. But what I'm going to say, DEJI, is that when a people are already acculturated to a perverse way of doing things, it takes time to knock out that culture. The NJS, as I said earlier, sanctioned some judges recently regarding a similar situation. Some lawyers, MBA says, is going to take them on, and now this one has come again. What the NJC ought to do, what the MBA ought to do again for the second, is to look at that again and say, the more you come, the more we'll sanction you. So that at the end of the day, the landscape of legal practice, the landscape of our judicial system will be rid of these persons that have the penchant to abuse our court processes and make us a laughing stock in the Committee of Nations. Not only in the Committee of Nations, even amongst Nigerians. Anytime the court, renders such a judgment now, just sample an opinion of lay persons who are not lawyers. Say this court, they've done their thing again. That kind of thing. And a court is expected to be respected. The pronouncement of a judge, if I were to use an example, is like what is next to God's pronouncement on earth. Because that judge has the power to pronounce that somebody be hanged by the neck. He has the power of life and death, literally.
Absolutely.
And that power ought to be used with utmost responsibility. So when you then see that these orders are just tumbling out of our courts, at the drop of the hat, you get so worried. Even as a lawyer, lawyer ought not to be surprised by the decision of courts. But when lawyers are now expressing their surprise by the decision of court, you must know that, well, the case has gone very, very bad for us. So my recommendation would be that just as the NJC apprehended that other matter without waiting for a petition to flow from any of the aggrieved parties before intervening and then sanctioning, the NJC can also do so on this occasion. I know that a lot of people say that, yes, if you are dissatisfied with the decision of the court, appeal, well, you may be dissatisfied with the decision of the court, just abide at the decision first. Every judgment of a court, every order of a court, unless set aside, must be obeyed. I have told you that the governor will not obey this one. And he has a judgment that has been reiterated by another order recently, saying that he remains the governor. So why will he obey this one? In any case, there are all other issues of law involved here, including Section 308 of the Constitution, which provides that once a governor is clothed with immunity, he can no longer be sued. He may sue if he has a defamation action, for example, but he cannot be sued. So he has a shield. And we are talking about a case that is not a pre-action matter, pre-election matter, that is not an election petition. This is a case that was just brought because of a defection. Okay? So why will you then sue the governor? Just as I've said. So there are a lot of legal issues involved in this matter, but all of them are not in favor, of this governor being bounced out of power because
there's one other issue I want you to speak to.
Defection.
There's one other issue I want you to speak to. It's something that has actually come up as a result of this. Some people have said, well, that look, this is essentially a carryover from the case of Amechi versus the PDP back then, that the judge was right, and that when you look at part of what the judge said, he to some extent he relied on what happened in the case between Amechi and Celestine Omehia. I mean, back then. What's your take on that?
Unfortunately, by legislative intervention, acknowledged by the Supreme Court and our other courts, the decision in Amechi and INEC had been cancelled, so to speak. That decision had been overridden by legislative intervention. Because following that decision, the legislature amended the Electoral Act of 2010 and provides that nobody shall be deemed elected by pronouncement of the court unless he has participated in all the stages of the election, including primaries. That was a legislative intervention to deal with the mischief of the Amechi intervention by saying that, yes, even if you didn't participate in the primary, as Amechi didn't participate in that primary, that you could be declared, as Amechi didn't participate in the election proper, because it was not on the ballot. The Supreme Court resorted to that to say that votes belong to the party, so votes could be transferable. After that decision, our courts have, through other decisions, say that it is only a candidate that is voted for. Votes are not transferable. And so if in 2022, a judge is still going back to 2007, 2008 to rely on Amechi and INEC, it's so unfortunate because there have been so many decisions since then that have overtaken the Amechi's decision. And there is a specific legislative intervention by way of a provision in the Electoral Act 2010, which now be superseded by the Electoral Act 2022, by the way, to the effect that if a candidate does not participate in all the stages of the electionary process, he cannot be declared a winner of that election. That's the decision in Amechi. So the other issue of transferability of votes, cannot be used in this instance to then make the point and adjudge, as the judge in Abuja has done, that the votes cast for Governor Umahi weren't transferable to another party. At this stage, we are no longer talking about votes that are already cast. We've done with election. We've done with election petition. We've done with pre-election matters. So at this stage, you are no longer talking about votes. You are talking about tenure. So the question is, can this tenure be truncated on the ground that the governor had defected? So a relapse to the issue of votes and their transferability, for me, is just fishing for something to then reach a conclusion that the court has reached. I am not sure that the judge, with due respect, is on a solid legal wicket to go back in time to the Amechi's case, which, as I've argued, has been superseded by a number of decisions.
Because I was actually surprised. I was actually surprised.
Electoral Act.
Yeah, because it was quite surprising to hear the judge say, "Look, collect that INEC should receive the names of the names of persons now submitted by the PDP, and the PDP on the basis of that basically nominated two persons, one as governor and the other as deputy, and these two persons are now saying that the governor should vacate office, that they want to take over. So it's baffling."
No, there's a lot of conflation here. There's a lot of asymmetric, collation of, strands of, an eclectic fashion. Bring a strand here, bring another strand from there, and then, collate everything and then say you've reached a decision. As I've argued, we are no longer talking about a pre-election or an election matter. Votes, vote cast, INEC. INEC has no role in the tenure of the governor anymore. Because we're talking about the tenure. So for the court to then, rule that INEC must do something, well, I don't know what the court was talking about. But as it is said, the bright side, sometimes it is argued that a judge has the right and the power to rule rightly or wrongly. And if you are dissatisfied with the decision of the court, you go on appeal to test the correctness of the decision that judge has reached. And my view, and I'm saying this with all sense of responsibility, is that given all that was said, given the fact that there was a judgment earlier given on the same subject, and the issue of multiplicity of action, the issue of conflict of decisions of court, given the fact that we're no longer talking about an election petition matter, we're now talking about tenure, given the fact that all the decisions of our courts are not in support of what the court has done, particularly because the case of Amechi has been superseded, and the fact that the issue of transferability of votes, cast is no longer a live issue as at now, the court ought not to have reached that decision. But unfortunately, the court has reached that decision, and that's why we're debating and discussing it.
Exactly.
Now. I hope that the judicial authorities, particularly the NJC and the NBA, will look at this, because it rankles. There's something that, when Nigerians say that law is an ass, to explain away the mercurial nature of our decisions now, it's disconcerting for a lawyer, because as a lawyer, basically, when you are told about precedents, stare decisis, and you are told about the certainty of law. Law must be, that's the essential attribute of law. So law must be predictable. If if a client comes to you and says, I want to go to court, you should be able to advise that client, prospective client, on what the state of the law is. But when the state of the law is in a flux, because errant judges are just ruling left, right, and center and all that, you just become a spectacle of derision, of laughter, and that's not too good. It then suggests that judicial determination is not a serious business. It's a serious business. It should be predictable so that, fairly you can say that this is where the decision is going to go. And that's why in other jurisdictions, judges, lawyers will appear before a court and the judge will say that, counsel, do you think that based on so and so your brief, what you've argued your brief is correct? And the counsel will take the hint and then say, what do you want to do to your case now? So you won't need to bother them with writing lengthy decision because they already know what the position of the law is fairly, rather than saying that yes, we are growing the rule of law and we are improvising, we are doing. There is nothing like that. It's an abuse of court process and it's a desecration of the judicial system.
All right, Mr. Igwe, thank you very much for your time. We just have to leave it there. Thank you so much for enlightening us on this very, very controversial judgment. Thank you so much for your time, sir.
Yes, thanks so much. Grateful.
All right, we'll take a short break and we'll be right back.
Opinions are free, facts are sacred, the truth is universal.
Now, let me ask you, Colonel. How, in practical terms, can we, for instance, de-escalate the tension?
Government must find the political will.
On DEJI360, we give you a complete dose of everything. Opinion, facts, and undiluted truth.
I hardly believe what politicians say in this part of the world.
A new Nigeria is possible, a future is possible, a great country is possible.
We'll delve into the issues, dissect it so that you can understand it and use it to take action. DEJI360, dissecting the issues.